On February 26, 2026, in Eureka, Kansas, Mr. Turner makes his first appearance before the court on 3 separate criminal cases. The defendant faces charges spanning from misdemeanor domestic battery and disorderly conduct to a serious level 3 felony for child abuse, plus 4 counts of violating a protection order. This hearing establishes the foundation of his legal defense as the court determines his eligibility for court-appointed counsel and schedules his preliminary hearing control for April 10, 2026.
Turner, Mr. Turner, that's you there on the screen, isn't it?
Yes, ma'am.
And, Mr. County Attorney Jill Gillette for the state. Mr. Turner, you're appearing by yourself today. You don't have an attorney yet?
No. I wanted to apply for a court-appointed.
Okay, where do you work?
I work for Achiever Well Service. We haven't really been working because of the weather. I work pulling units. And I'm living with my dad and helping him out when I have money and car insurance, pay my own with groceries and my own food and
Okay, hang on. Mr. Turner, remind me, do you live here in town in Eureka?
Not no more since I got the no contact order. I live with my dad in Hamilton, Kansas now.
Does he ever come this way where he could bring you down and get you an application for court appointed, or?
I can try. I can grab one then.
And you fill it out and leave it here with Missy? Okay?
Yeah.
The judge begins the hearing by confirming the defendant's identity and determining he lacks legal representation. Mr. Turner immediately requests a court-appointed attorney, triggering the court's obligation to assess his financial eligibility under the Sixth Amendment. Under the Sixth Amendment to the United States Constitution, as interpreted in Gideon v. Wainwright, 1963, criminal defendants facing potential incarceration have a fundamental right to counsel, and states must provide attorneys for indigent defendants who cannot afford private representation. The Supreme Court later clarified in Argersinger v. Hamlin, 1972, that this right extends to any criminal case where imprisonment is actually imposed, not merely where it is authorized. Kansas follows these constitutional mandates through its own statutory framework, requiring courts to evaluate defendants' financial resources against established eligibility guidelines before appointing counsel at public expense. Here, Mr. Turner explicitly states he wants to apply for court-appointed counsel, placing the burden on the court to determine whether he qualifies as indigent. The judge immediately begins this financial inquiry by asking about his employment, living situation, and income, standard factors and indigency determinations. The defendant's explanation that Weather has reduced his work hours and that he lives with his father while contributing to household expenses provides the factual basis for the court's eventual eligibility finding. The right to counsel serves as the cornerstone of fair criminal proceedings. Without it, defendants like Mr. Turner would face complex felony charges alone, unable to navigate procedural rules, negotiate with prosecutors, or mount effective defenses. Courts that fail to properly screen for indigency risk, either denying constitutionally guaranteed representation to needy defendants or wastefully appointing counsel to those who can afford private attorneys, undermining both individual rights and public resources.
So I think you're going to get an attorney, but we need to get you appointed sooner rather than later. You have these 3 cases going. In the 26 CR 29, you're looking at domestic battery and disorderly conduct. That's a B misdemeanor and a C misdemeanor. On the domestic battery, you could serve up to 6 months in jail. On the disorderly, you could serve up to 30 days. You could pay a fine up to $1,000 on the domestic battery and a fine up to $500 on the disorderly. In the 26 CR 29, that's domestic battery and disorderly conduct. 30 is the one I needed to pull back up. And 30, abuse of a child, charged as a felony, a level 3 felony. That's pretty serious. Your sentence could be anywhere from 55 months in prison to 24 months. Your fine can be up to $300,000. And then in the 31 case, you're charged with 4 counts of violation of a protection order. Each one of those could carry up to a year in the county jail or 4 years, $2,500 fine on each one of those. Yes, sir.
I believe we're doing that case on the 24th because I got told nothing about.
We just went ahead since you had that third one and put it on today so you didn't have to come back on the 24th.
Yeah,
Okay, because I
don't get it. Maybe you don't get a take. So
make a little bit more money.
There you go. So Missy, when will his PHC be for these?
April 10th at 1:30.
I'm gonna have you come back on all of them, April, and let me go ahead. So you are working or were working for Cheevers?
Bill Cheever, yes, in Madison, Kansas.
And what do you make on average per,
Maybe 2,000, maybe.
What'd you
But here
say?
lately, it's been not even 1,500 here lately because of the weather and stuff.
All right.
The judge details the full scope of charges against Mr. Turner across 3 cases, explaining potential penalties ranging from misdemeanor fines and jail time to substantial prison sentences for the felony child abuse charge. She then proceeds with the financial questioning necessary to establish indigency for court-appointed counsel. Under Kansas Statute Annotated Section 22-4504, courts must appoint counsel for indigent defendants, defined as those unable to employ counsel without substantial hardship to themselves or their dependents. The statute requires judges to consider income, property, debts, and family obligations. Additionally, Kansas Supreme Court Rule 102 establishes detailed financial eligibility guidelines, generally qualifying defendants whose income falls below 125% of federal poverty guidelines. The judge's methodical inquiry into Mr. Turner's wages, rent, insurance, utilities, and dependents directly implements these statutory and regulatory requirements. The judge systematically applies Kansas's indigency framework by examining Mr. Turner's $1,520 monthly income against his $450 rent, $120 vehicle insurance, approximately $100 electricity share, demonstrating the substantial hardship calculus required by Section 22-4504. His disclosure that he has no children of his own and no legal support obligations simplifies the analysis, confirming he qualifies as a family of one under the eligibility guidelines. This thorough documentation protects both the defendant's rights and the court's administrative record. Precise indigency determinations prevent the constitutional crisis of unrepresented defendants while safeguarding public funds from misuse. Courts that rubber stamp appointments without proper inquiry strain limited resources and may appoint counsel to defendants who could pay, while cursory rejections risk Sixth Amendment violations that could overturn convictions on appeal, wasting far more resources than careful initial screening requires.
Do you pay any kind of rent or mortgage?
$450 vehicle insurance,
Okay, how much for vehicle insurance?
about $120.
Do you have any vehicle payments? Do you have any cell phone?
I
How
do
much?
pay. I do
Any
help
other-
my dad.
How much are they?
Where he lives at right now, I mean, with the electricity alone is 500, so I try to help him meet him halfway on that, and it's about 100 something maybe.
Do you have any children that you support or help support?
I mean, except for my fiance's kid, but I haven't talked to her since I got in trouble for the breaking the contact order.
All right, so you don't have any legal support?
No, have no kids of my own.
So you're basically a family of one? You don't
Yes,
have a
ma'am.
spouse, you don't have children? Well, actually, you will qualify for court appointed. Back Missy later this week to find out who is appointed.
Yes. So he doesn't need to fill out the application on Thursday.
Can I get
Okay.
Missy's
620-5835. That's the court number, but it'll get you to Missy.
Okay, so 620.
Yes,
Yes.
Missy, that is right. Okay.
Yes, that's correct.
Okay, so
Thank you.
call her later this week and she'll tell you who that attorney is. About Friday, is that what you think, Missy?
Yeah, that'll be fine.
Okay, call Friday and find out who your attorney is and then call your attorney.
The judge completes her financial inquiry, determines Mr. Turner qualifies as indigent, and approves court-appointed counsel. She provides him with contact information to learn his assigned attorney's identity and emphasizes the importance of communicating with counsel about scheduling conflicts across multiple jurisdictions. Once indigency is established, Kansas Statute Annotated Section 22-4506 requires courts to appoint counsel as soon as feasible after charges are filed, ensuring defendants have representation at all critical stages. The Supreme Court in Coleman v. Alabama, 1970, held that preliminary hearings constitute such critical stages where counsel's absence can impair the entire trial process. Additionally, under Kansas Rule of Professional Conduct 1.3, appointed attorneys must act with reasonable diligence and promptness, making the court's instruction for Mr. Turner to contact his attorney immediately upon assignment a proactive measure to ensure effective assistance. The judge's approval of court-appointed counsel satisfies both constitutional and statutory mandates, with her instruction to call Friday for the attorney's name, implementing the as soon as feasible requirement. Her subsequent emphasis on informing both attorneys and all your attorneys about scheduling conflicts across Leon, Butler, and Greenwood counties recognizes that Mr. Turner's multiple pending matters create coordination challenges that diligent counsel must address, directly invoking the professional duty of competent representation across jurisdictions. Timely appointment and effective communication between client and counsel prevent procedural disasters. Missed hearings, conflicting court dates, and inadequate preparation that can result in warrants, bond forfeitures, or waived defenses. For defendants juggling multiple cases across county lines, as Mr. Turner is, proactive judicial management and lawyer diligence together protect both individual liberty interests and court system efficiency.
Doesn't do any good to appoint an attorney if people don't. I never know which one's due and which one's done. Turner, Ms. Gillette, anything first? I'm sorry you were muted. I didn't hear you.
Now, are we setting all of them all on the same day, April 10th?
Yes, and same attorney on all of them, if you can, Missy. I know
Yes.
some of them we have, yeah. And then I'm going to continue that $10,000 bond that you made on at least one of the cases with Florio. Any bonds you've posted are continued with added conditions that you call your attorney and be ready to go on the date that we gave you.
I do have court. I got called for a reevaluation for my last case from there when I got picked up for the warrant for when I had seen you last was for the stalking. And I don't know when in April it is. I want to say, so when I get a hold of my lawyer, is there if I let him know so he can let you guys know, possibly set for a different date? Because that's in person and
Attorney about it, yes. If they're the exact same, do you know they're exact same time, or you just think
I think they might be, but I'm not for sure because my wallet is at my fiance's house. Like I said, I can't have no contact with her. And
Okay.
there was one more question I wanted to ask you. What would be the way to go around to possibly being able to? I know with the felony charge with my son, the oldest, I wouldn't be able to see him, but my fiance and my youngest, which are the two for the DB was with her, and disruptive behavior, I think, was the other charge, and that was
Disorderly
against my
conduct.
disorderly conduct, and that was for my youngest. I was wondering if I could.
Talk to your attorney will know how to make the appropriate motions to see if that can be modified.
The judge continues the $10,000 bond with added conditions requiring Mr. Turner to contact his attorney and appear as scheduled. Mr. Turner raises two concerns: a potential scheduling conflict with a reevaluation in another county, and his desire to modify the no-contact order to see his fiancée and youngest child. Under Kansas statute annotated sections 22 to 2008-02, courts may impose reasonable bond conditions to ensure defendant appearance and public safety, including requirements to maintain contact with counsel. Regarding protection order modifications, Kansas statute annotated section 63,307 allows courts to modify or vacate protection orders upon motion and hearing, though such requests require formal legal process rather than informal judicial inquiry. The Supreme Court in United States v. Salerno 19087 upheld preventive detention when supported by clear and convincing evidence of dangerousness, but also emphasized that release conditions must be tailored to legitimate governmental interests here. The no-contact order protects alleged victims while potentially infringing on parental relationships that courts may balance through proper motion practice. The judge appropriately channels Mr. Turner's concerns toward formal legal channels rather than resolving them extemporaneously. By directing him to tell both attorneys about scheduling conflicts and stating his attorney will know how to make the appropriate motions for contact modification, she reinforces that these matters require adversarial process with prosecutorial input and judicial findings, not casual courtroom conversation. This procedural rigor protects both Mr. Turner's interests, ensuring full argument for modification, and victim safety, preventing unilateral judicial erosion of protective orders. Judicial restraint in first appearance settings preserves the integrity of subsequent proceedings. Had the judge informally discussed modifying the no-contact order without notice to the prosecution or findings on the record, any resulting modification could be challenged as procedurally defective, potentially harming Mr. Turner's case and endangering protected parties. By insisting on proper motion practice, the judge ensures durable, defensible outcomes.
Okay.
But going back to that one point you raised, absolutely tell both attorneys, the Lyon County attorney was a Lyon or Lynn.
Lying.
Tell the attorney in Lyon County, tell the attorney in Butler or in Greenwood what's going on in Lyon, I'm sorry. In other words, let all your attorneys know what the other ones have going on.
Yeah, I don't have an attorney for Lyon County. It's just for a reevaluation.
Your hearing is set
What
Miss
time?
Gillette, you just went out. What time did you say, Miss Gillette? We lost you.
4 p.m.
But do what you're supposed to in both counties. Now's not a good time to screw up in either one.
I've been doing my best, and I'm
Okay, well,
so close to getting done with everything. And
well,
I
your
get him.
attorneys can help you.
All right, thank you.
You're welcome. You may go, sir. Missy, this Madison Roads, what day was that that you said was coming up with the application? That wasn't today.
The court approves court-appointed counsel for Mr. Turner based on his financial eligibility, continues his $10,000 bond with conditions to contact his attorney and appear for all scheduled proceedings, and sets his preliminary hearing control for April 10, 2026 at 1:30 p.m. on all three cases. The judge instructs him to contact the court clerk Friday to learn his assigned attorney's identity and to inform all counsel about his pending reevaluation in Leon County to address potential scheduling conflicts. Mr. Turner is directed to pursue any no-contact order modifications through formal motion practice rather than informal request. This hearing illustrates the foundational architecture of American criminal procedure. The Sixth Amendment right to counsel, implemented through state indigency schemes, ensures that economic disadvantage does not translate into legal disadvantage. The careful financial inquiry we witnessed examining income, expenses, and obligations reflects the constitutional mandate from Gideon that justice cannot depend on wealth. Yet the right to counsel is merely the threshold. As the judge emphasized, defendants must actively engage with appointed attorneys, communicate across jurisdictions, and pursue remedies through proper channels. The procedural safeguards that protect defendants, formal motion practice, prosecutorial notice, recorded judicial findings simultaneously protect victims and public safety by ensuring that protection orders and release conditions rest on documented evidence rather than casual conversation. For viewers, this case demonstrates that effective criminal defense begins not in dramatic trial confrontation but in meticulous administrative attention, knowing your court dates, contacting your lawyer, and understanding that constitutional rights require personal activation to become constitutional realities. If you or someone you know faces criminal charges without resources for private counsel, contact your local public defender's office or court clerk immediately to request indigency determination. Delay can forfeit critical rights. For those interested in criminal justice careers, observe first appearance hearings in your jurisdiction to witness how constitutional promises become procedural practice. Finally, support organizations like the Sixth Amendment Center or your State Innocence Project, which work to ensure that the right to counsel guaranteed in Gideon reaches every defendant who needs it, regardless of income or geography.